test 1 2 1 2. One two one two 1 2. Mic test 1 2 1 2. 1 2 1 2 1 2 1 2 1 2. One two. This is H. G lah. G.
Good morning. Yes. We have reconvened today's proceedings in order to hear oral argument in the recusal application of Advocate Siminya. Argument will be heard in the following sequence. Advocate Muroka on behalf of the Minister, Advocate Wala on behalf of the NPA, Advocate Vani on behalf of the Kalata Group, and Advocate Vasson on behalf of Advocate Siminya. Each party shall be allocated 30 minutes to present its main argument, and the applicants will be allocated 10 minutes in reply. Advocate Muroka. Yes. Advocate Sonny, we can't hear you. If you could just raise your voice. Now we can hear you.
Galata people say in their affidavits, what Piccoli himself says in his affidavit about that policy. Again, the policy took center stage in the Divisional Commission because Piccoli was of the view that I'm being dismissed or I'm being held to account because of the policy and how I behave vis-a-vis the new policy and the old policy. So again, in the Divisional Commission, it was central. Mr. Semenya's role in that commission was, different. He's Mr. Homo and New London Commission. He was an advisor, he led evidence, but he was central in the General Commission. And we say, in that respect again, he can be central in this commission. We then move to his role, the process role between himself and Mr. Vani is his common cause. The Galata feminists find nothing wrong in what he did there. They keep insisting there was a letter and a ruling from you or from the commission that says you can, and everybody can use their own witnesses. We don't have sight of such a ruling from yourself. The only ruling that we have is the ruling of the 19th of September. And that's the only ruling that we abide with. We take issue with the fact that Weber Wenzel and Mr. Semenya had a private conversation, and we say, people will say, other commissions, people talk and people do all sorts of things. We are saying, the rules of this commission set out very clearly what's going to happen. The chairperson in the commission direct how witnesses are going to be called, direct who gets called, direct. We have now applied for an extension. You are the people who applied for an extension. We didn't apply for an extension. It is your commission. You set the rules. You make the rulings. We abide by those rulings. Unless we need to take the rulings and review, we have no intention of doing it. So for Semenya to do, you're in the front of his own with Mr. Van, we say that is unacceptable, and that raises a perception that he is not going to treat all the witnesses equally and fairly.
But just is there any indication that only Mr. Van can lead his own clients? Is it a closed rule and no one else? And if you, counsel, wish to lead your own client and to apply, would we have said no? Only Mr. Van is so. In that sense, was it preferential, and is it discriminatory?
I will answer it in two parts. The first part is that, we know that we did not. We submit that because Mr. Vanya's witnesses are so central to your fact-finding mission, that the ruling should have come from the commission. That's what we say. Simply put, that's what we say. Simply put, we don't have objections with coming to the commission and saying, for these reasons, we think, and Mr. Vani, by the way, has put his reasons why he thinks he's. It's a discussion for another time. But it's a discussion that you listen to, you hear what the other parties have to say, and you make a ruling. That's all we're asking. We're not asking that every witness is. We are saying any deviation must be in terms of the rules that you gave to us, that you must make the decision. Sometimes it might not be necessary to hear us, but at least we have the confidence that we would have thought about it. We would have thought, does this help our fact-finding mission or does it not? We're not saying only, but what we're saying is that the way he did it was unfair. We're saying the way that he did it was untenable. But it doesn't mean that the commission can make a ruling on the issue. That's all that we're saying.
But Ms. Moroka, can we come to a rescue in that regard, having regard to the fact that the objection issue is yet to be determined by this commission? Siminya had with Mr. Khan.
Does it mean I don't need to talk about it?
I want to know how we can assist you when we have yet to rule on that issue.
I guess, Chairperson, all we are saying is that when you do rule, and it's not even necessary to hear us, all we are saying is that it must be your rule and not Mr. Simon's. He doesn't have all the evidence needed. He doesn't have the authority to do so. That's all we're saying. And if you could make a, we are very, the minister, if you see from our heads, we say she only assumed office in 2020, last year. So you would imagine that her affidavit will not be extensive. Mr. Selina, Mr. Malani can read her evidence. I don't know what the other colleagues want to do.
Yes.
About that. We have no issues. Anybody can lead our minister. She's self-confident and she can be led by anybody. And she doesn't need much protection. All we are saying is that it must be a relief from the issue. As regards the standard, very quickly
You have 2 minutes,
we point out
Ms.
at
Moroka.
we point out, Chair, at page
Rather give us the paragraph.
rather give you the paragraph. The paragraph will be paragraph 97. And I'm very sorry that after 97 you see a 63.1 and a 63. Paragraph 97, page 116. We talk about the code of good practice that all legal practitioners are bound by. And it tells you what he can do and what he can do and what conflicts he must avoid and what conflicts when he sees a conflict, what he must then do. And then finally, Chair, we talk to his role as the evidence leader. I think this is the most important part of our submission, to the extent that it's been suggested that he has a role similar to that of a prosecutor. We say some of us have been prosecutors. There is a delineation. Prosecution authority is set out in the Constitution. The powers are set out in an act of Parliament. Very different from what an evidence leader in this respect is. You can't, when you want to go and see a magistrate or a judge in chambers, march in as a prosecutor to go and talk to the judge and tell him, I think I will leave this witness today and tomorrow. Prosecutor can't do that. A prosecutor can't leave his colleague to go and talk to the judge. A prosecutor prosecutes with the best of his or her ability in the prosecution. The evidence leader, according to the rules of this commission, leads under the direction of the commission.
Yes, Ms. Moroka, I'm just reminded that you have already gone through your time allocation. You may proceed.
Well, I was going to say time allocation minus the questions, but
That included.
but that
That
included,
included.
or then that's serious, Madam Chair. But we are just saying that in this regard, that to the extent that the evidence leaders are an extension, they do not have the power to make decisions. They're a non-decision making arm of the commission. They act under the direction of the commission. They are there to assist the commission. They are there to lead witnesses on behalf of the commission, so that the work of the commission is made easy. That is the standard. Therefore, that standard we submit implicates all the cases that we've cited in our hands. It implicates Saru, it implicates Bennett, and all of those cases, because
It would implicate SARU, notwithstanding that the evidence leaders are not judges.
notwithstanding that, because they are assisting the judges, they are there to talk to the judges. And
But they don't make the ultimate recommendation.
No, they don't. That we, I started there, Madam Commissioner, that they don't, they're a non-decision arm of the commission. They don't make the decisions.
They shape the evidence of the commission.
Shape is a strong word. I wouldn't want to say they shape. They assist with the evidence and take it to, and address you on it. So that if you look at the arms deal case, I don't know what the official definition of arms deal is. It was that the evidence leaders themselves didn't help the commission. They asked questions that were non-helpful. They were not robust enough. They were not, and the commission itself didn't do the job. So we are saying the two parties, the evidence leaders and the commission, are there to assist each other in getting to the truth. And there isn't a line such as you find in the prosecution, where the prosecutor and the defense lawyer are in the midst of, as we call, they've descended into their arena. The judge doesn't descend, the prosecutor descends, the defense advocate descends. The commission is a different animal, but the commission, the judges that sit there and the senior counsel that sit there must bring to bear an impartial, open, and history from Tilwala, from Kadime. You can't do that because you're not free, you're not open, you're not unaffected. Those are our submissions.
Thank you.
So what does that impact on the position of the commissioners? If you accept that the evidence leaders work subject to the direction of the commission, as I understand it, the problem is with the evidence leader. How does that impact on the ability of the commissioners, this panel, to do its work fairly and properly?
I would say it does impact, because he or she, as the evidence leader, will go and interview the witnesses, will formulate the questions once there's an interview, formulate the question, formulate to what extent he probes that statement, and you as a commissioners are listening to it. You are affected by what you're hearing. At the end of the day, the evidence leader then summarizes all of this evidence and gives it to you and say, look at what I found out. Look at what the evidence presents. But he's the one who went and interviewed and probed and looked. You as members of the commission are not doing all of that. That is why you need that system.
That is to suggest that we have a passive role in
No,
listening
no.
to the evidence.
And that is why the commission referred you to the arms deal case, where the complaint there was that the commissioners were too passive, too uninterested, too willing to believe everything that they heard without probing. Your duty is to probe, but you probe with the assistance of the evidence.
Thank you, Ms. Moroka.
Thank you.
We'll take a short adjournment whilst they are trying to attend to the sound system. We'll adjourn until we'll adjourn until 11:05.
But I can't hear it. 1 2 1 2 1 2 mic. 1 2 1 2 mic test 1 2 1 2 1 2 1 2 1 2 1 2 1 2 3 4 5 6 7 8 1 2 1 2 1 2 mic test 1 2 1 2 1 2 1 2 1 2 1 2 1 2 1 2 1 2 1 1 1 2 1 1 2 1 1 2 1 1 2 1 1 1 1 1 2 1 1 2 1 1 2 1 1 2 1 1
Election Parties Commission. It was described as a it was taken on review and
test 1 2 1 2
Party's credibility quite significantly now.
oh, it's not in party.
No, it wasn't him, it was the other one.
It was but it also Farms Commission. It was the judge Sari.
Yeah, yeah,
And it was described as a farce.
yeah. And he went on review, Corruption Watch to get it set aside.
And I think, if I remember correctly, there was a reason why it wasn't investigated. Because it had to do with what they could do.
Yeah, yeah. It was a cover-up. It was a shame.
Yeah.
Yeah.
Howard? We're on Twitter.
Yeah.
Has the judge appeared in the court?
Which one? The one who was
Plane. She's our.
Is this the counsel for Abrams? He was here last week, isn't he?
That lady, I don't think she's.
Yeah, I
Why
think
she's
she's...
here?
No, no.
Did you say it's Beklane?
how do you spell?
PH
He's the one.
It's similar. And she must give a judgment in January. PHA, LH.
Poshia Pasan, the name is Poshia.
Yeah, H. H. Pahlane.
Pasan, no.
No, it's not like that.
Not like that.
Yeah, I'm getting the spelling from.
PIH.
HLA.
Okay.
No, after is Pa.
Thank you. I figured you were really busy. No problem. Howard did mention that he would speak to you at some point, but I just want to introduce myself. Lovely to meet you too. Thank you.
Are you related to
Dr. Yusuf Khan.
in
Judge Moshe and his son
This one.
have been arrested.
Yeah, but the she.
One, two, one, two, 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 one, 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 two,
No, she's still coming. She doesn't appear.
one, two.
I've heard so.
Yeah, but
I would love to
next to
know
one
one day my dad went to the funeral.
One, two, one, two, one, two.
What is the state account? We're working with the client to make solutions in whistleblower protection. So it's that sort of public role. So I'm enjoying it, very grateful. But I want to gain more experience in litigation. I did my articles in a corporate firm or Cumberland
Yeah, I know it's the right
But anyways, she was every time I speak to her, I would also tell her Happy Memorial. Well, like I said, it's thankfully, I appreciate it.
Firstly, over time, we're supposed to be back at 11:05.
Did Chris find somebody?
Sorry?
Did Chris find Hotel? Did he find somebody to join his team?
Oh, yes, he did.
He did?
Yeah. Rufus. Rufus.
But is he still looking for someone?
No. He found someone.
But he doesn't want someone at all.
Because I'm looking for a place for Tiara.
But isn't Tiara going to Congo?
Yeah.
Mr. Kwala?
We have submitted our written submissions and they are before the Commission for reading. I intend not to repeat exactly what is said in our written submission, but we stand by them. But what I propose to do, I just want to give a summary of the background and then point out two issues out of that. And then I will then just point out the test which we have already set out in the heads and make submission as to why it should be the SARFU test that is applicable than the prosecutor test as is suggested by the evidence leaders. And after that, I will briefly deal with some of the arguments that I have picked up in the heads of arguments of the evidence leaders. Commissioners, may I begin? It is common knowledge that the terms of reference in this commission include determining whether there was any political interference in the investigation and the prosecution of the TRC cases. Central to that inquiry is the prosecution policy amendment of 2005. The prosecution policy amendment, as other parties contend, was the principal instrument through which the executive influenced the prosecutorial decision-making. At least we understand that to be the case of the Galata families. It is common cause, commissioners, that the prosecution policy was taken to court in which its constitutionality was challenged. And it is common cause that the NPA and the Department of Justice were represented in those proceedings in court by Advocate Semenya SC.
Yes, sorry, if possible, you can take us along to indicate more or less where you are on your heads.
Well, Commissioner,
I know you're making a summary, but
Commissioner, that is what I indicated, that I intend not to repeat what is in the heads of argument. We stand by everything that is in the heads of argument.
Okay.
Unfortunately, my planning was not to go line by line or theme by theme in the heads of argument.
Okay.
I took a view that the heads of arguments are there and need not be repeated in argument.
Okay.
But what I say indeed is covered in the heads of argument in the summary that I'm giving.
Yes.
Thank you, Commissioner. I was at a point where I was saying Advocate Semenya represented the NPA and the Department of Justice in those proceedings, defending the constitutionality of and the lawfulness of that policy. The memoranda prepared by Advocate Mshe, who have placed them before you, he was the acting NDPP at the time. Those memoranda demonstrate that Advocate Semenya, not only did he represent the NPA and DOJ at the court or at court, he also advised the NPA that it should appeal the judgment. We say that in paragraph 23 of the
yes, Mr. Kwala. I would like to hear you more with regard to your reliance on the memoranda.
Yes.
In particular, the one that was prepared for former Minister Jeff Radebe.
Yes.
You seem to place reliance on that memoranda to show that Advocate Semenya had confidential information about the Nkadime matter.
What the point we are making, Chairperson and members of the Commission, is this. An advocate who appears in court on behalf of a party certainly does not move from chambers to court. That's not the first thing that one does. You first consult with the client, get to know the case of the client. Even at that stage of consultation, as you prepare for the for filing of the affidavit, you advise the client. You strategically give guidance on the case of the client. But more importantly, a client will not simply say, "We've got a case, please go to court." The client is going to tell you the genesis of, in this case, for instance, there has to be given a genesis of the policy. Why was this policy conceived? How is it going to be implemented? And everything that is confidential around even everything that is confidential around that policy. So it cannot, what those memoranda demonstrate is that indeed there were discussions between Advocate Menya and the client. At that
Do they
senior level,
indicate the nature of the discussions?
they do, but what they do not.
If they do, please refer me to the relevant parts of the memoranda
What
where this is done.
What they do not do, though, which is something that I wanted to address, is that they do not tell you that this confidential information was mentioned. But I would not imagine, it is something that I was going to argue later, I would not imagine in a hearing such as this that you would require a client to say, I object to the judge presiding, for instance, in this. Let me make an example that I've thought of. Suppose an advocate represents a client in a criminal proceedings, and that accused says, actually, I did kill the person, the deceased. We know the ethical implications of that. And now the advocate becomes a judge, or the attorney becomes a judge. And would you expect that client, when he applies for the recusal of that judge, to say, remember, on 18 September, I told you that I killed this person? Then that confidentiality is gone. So the point I'm making is, you wouldn't expect, as the evidence letters suggest, that we state that this is the confidential information. We said X, Y, Z. That it should not go to that extent.
Yes.
All you need to do is to demonstrate by evidence that there was information that was given. And if we contend that it is confidential, then just give surrounding evidence to show that. So
you would submit that the memorandum does not disclose the confidential information that is alleged to have been obtained by Semenya.
I'm saying it should not even go to that extent. The inquiry
Yes.
should not go to that extent, because then it is no longer confidential. The confidentiality is lost, particularly in the example that I give. Then that accused is still going to be tried. And it is on record now that he has said, I have committed this crime. So then what? That is why we submit that you wouldn't go to the extent of spelling out that this particular information was disclosed. So for them to say we are not making a case because we do not set out the confidential information, I submit it is wrong.
The reason why I was asking that is because in your written submission, I think it's paragraph 30 of your written submission, you rely on the memoranda as an indication of such consultations.
As an indication of those consultations, as an indication
and
of
as
the
an
advice.
indication of the privileged information that was shared with Advocate Semenya.
It goes without saying, Chairperson, that in a litigation, there will be information that will be disclosed. There will be confidential information that will be disclosed by the client.
And it does the memoranda does nothing more than that.
The memoranda does nothing more than that.
Thank you.
Mr. Gwala, can I ask a question? Mr. Gwala, aren't many of the things set out in that memorandum just a matter of historical fact anyway? There were these amendments. The amendment set out the rationale, the procedure. There was a court case. The judge struck it down.
Advocate Semenya represented.
Advocate Semenya gave advice. The NPA gave advice. The PCLU, according to this memorandum, disagreed with that advice. And it would seem that the minister himself disagreed with that advice because there was no further appeal. Aren't these historical facts?
Be that as it may, the point we are dealing with here is whether Advocate Semenya is conflicted. That's the issue that we are dealing with. We say he's conflicted because he has had an opportunity to gain access to those privileged information and to
What
represent.
privileged information?
That's the point. That's the point I've just addressed now, Commissioner. To say, if we are to say an applicant for recusal must then, in the affidavit, write down and say he is conflicted. I've given him privileged information, which is A, B, C, D. That then infringe on that privilege itself. And the point I'm making is it would not be expected that such an applicant go to that extent because, for instance, in the example I've made of the accused, that person is still going to be tried. Now, what is he going to say to court further if he comes to court and say, Judge so-and-so, recuse yourself because I told you X, Y, Z? We say it should not go to that extent. Suffice to demonstrate that one has represented, and two, that he was given a privileged information should also be inferred from the facts, because there is no advocate who goes to court without having had a consultation. And when you get to consultation, we've all been practitioners, including those who have retired. We've all been practitioners. We know what happens during consultation. You can take judicial notice of that.
But shouldn't we be entitled to information with regard to the nature of the consultations that were had? To be able to see that those consultations impinge on the terms of reference of this commission.
What we know from the facts is that the NPA had a policy. The policy was challenged. Advocate Semenya was brought in to advise on that policy. He has given an advice on that policy. That you need to appeal at least appears clearly from the.
As Commissioner Gabriel has just stated.
Yes.
Those are historical facts.
But his was not just to say appeal and making he was actually defending the very prosecution policy that is before you.
You see, absent what the chair has said and what Commissioner Gabriel has said, would steer us towards the realm of speculation, wouldn't it? Because the facts are not there, not in the memorandum, not in the historical facts. So where are we?
We are not in the realm of speculation, Justice Komo. We cannot be speculating. We even see what Advocate Semenya argued in court. We see it is before us. It cannot be speculation.
What is before us is the judgment in the Nkadimeng matter.
Yes, in paragraphs 11 to 12 and 16 of that judgment, the judge tells us what submissions.
Yes. So are we to confine ourselves to that, or should we extend it to how you have suggested to us that it should extend to the memoranda that you have submitted?
All this must be taken together. All this must be looked at together. You've got to look at the memorandums prove that there was a representation. The court judgment proves that there was a representation, there was submission that were made. The memorandums tell you that he even gave and advised that we should appeal.
Which advice was not
It
taken up
Yes.
by your clients?
Yes, it doesn't matter. It doesn't matter. What matters is that he did give an advice. What matters is that he did appear in court and represent
Yes.
the NPA. That we did not action the advice is neither here nor there.
Yes.
For purposes of determining whether there could be a conflict of interest.
And then there was the issue that he gave an opinion to your clients, and that opinion has not been discovered.
Yeah, we say so also in they say so also in the affidavit that they are looking for that. Remember, commissioners, this thing arose 17 years ago. It is not unreasonable to expect that some of the document may disappear given the time lapse that has occurred. But accept that for now we have not provided you with that opinion, right? Because it's not before you at the moment. They were hoping to get it and they couldn't. But does that take away from the fact that Advocate Semenya represented the NPA? He gave advice to the NPA. We submit it does not.
Yes, and Mr. Kwala, I see that the DOJ and the MPA were not in an adversarial situation or a conflictual situation, and there's no suggestion from your side that because there is a conflictual situation, you are being prejudiced. That is not your case. That's not what is coming out. Am I right?
No, you are not right. You are not right, Commissioner. That's the essence of this application.
Say again, sorry.
That's the essence of this application, that to have Advocate Semenya presenting evidence is going to prejudice the NPA. That's the essence of this application.
How will it prejudice?
He has got confidential information that was given to him during those consultations.
What confidential information is this? Why can't it be disclosed in your founding papers?
Well, for the reasons that I...
You say for the mere fact that he was briefed on an issue that related to the constitutionality of an amendment of a policy, he had confidential information.
Yes, that's what I say. But what I say is that you may take a judicial notice yourselves that a counsel does not just go to court. He consults with the relevant people, and he gets impacted with knowledge, not only the knowledge that you see in papers. There will be, for instance, the rationale of the policy will have to be disclosed to him. It may even have been negative for the NPA why they raised the policy. But
suppose it was not.
So, if it was not, it was not. But what the NPA says is we have given him confidential information.
Without disclosing the nature of the confidential information it has given him.
Justice Kabeba, I've made a submission as to why one would not have to go to that extent.
That's fine.
Yes. But, so I was saying central to this inquiry then is that policy that we are debating, which Advocate Semenya has advised on. Now, the issues developed. The Kalata families we can call it the Kalata, is a group of families, but led by the Kalata. They realized that Advocates Menya was a party, was representing the NPA in court. And they realized that they intend to place this policy as evidence of political interference. And they say, because Advocates Menya has this prior engagement with the NPA on this policy, he is likely to be conflicted. Then they wrote to you. They requested that he be excused for that purposes. A ruling was made. I make no moment of the fact that we were not copied or it was not communicated with us for present purposes, of my argument. They wrote and raised this concern. The chairperson considered the concern, consulted with Advocates Menya, and then the chairperson issued a directive. The directive was to the effect that he's going to be severed from participating in matters relating to the policy. Now, two things arise. Oh, sorry, before I say two things arise, we now know that subsequent to the objection by the NPA, by us, so to say, and after the last meeting, after the 10th of November when we were here, we know that Advocates Menya did consult with the former acting NDPP on matters relating to the police. Now I say two things arise from this background. The first is this: there is already a public perception that the participation of Advocates Menya, at least insofar as it relates to the prosecution policy amendment, will raise a public perception of bias. Why do I say this? I say this because the Kalata families saw it as such. So somebody else will see it as such. So there will be that public perception. That's the first issue. The second issue is that the caveat or the protection that the Commission saw it necessary to put in place so that the public perception of bias is avoided has shown that it is not workable. Not workable in the sense that we now know that Advocates Menya consulted with the former NDPP on a matter relating to the policy, which it was indicated or it was directed that he would not participate. So just on those two aspects, the fact that someone already, Kalatas are informed, they are informed, they know the facts, they saw the potential of a public perception of biasness. And I submit they meet the Sarfu test. But we know that what was intended as a protection against that is not workable. Hence, we have record of Advocates Menya having consulted with a former NPA, acting NDPP. Chairperson and Commissioner,
can I just inquire about this interview by Advocates Menya with Advocate
Ramaite.
Sorry?
It's Advocate Ramaite.
Yes. Supposing Advocate, let's say Nalane or Advocate Soni interview, would you have said anything different?
I don't think that should be the basis of the inquiry, Justice Khomo.
No, particularly that he won't be involved in the leading of evidence as regards the Galata family group, that's a given.
Particularly that?
Advocate Semenya won't be involved in leading the evidence relating to the Galata
No.
group.
It's about the policy, Justice Hall, not the Galata people. The objection was that, the objection by the Galata family was that you have been involved in representing the NPA in a matter that relates to this policy, which we intend to put up as evidence to demonstrate that there was political interference. It was not so much, I think the objection about who leads evidence or not is something else. The direction that the chairperson gave, at least on the subject that I'm discussing, was in relation to whether Advocate Semenya would lead evidence in so far as it relates to the prosecution policy.
Okay.
Thank you, Justice. I'm moving to the next point. The next point now relates to the test.
Having regard to your time that is left, having regard to the time that is left, Mr. Gwala.
I do not know how much time I'm left with the chairperson, but can I just make this point? The test is set out in SARFU and in the matter of Masuku. Chairperson, we have said in the heads of argument, we accept that Advocate Semenya is not the decision maker. The commission is. Although he does make decisions in the process, like which witness to call, where, and so on, but we accept that point. Ultimately, he's not going to make a decision on the issue. However, Advocate Semenya controls the evidential record. Advocate Semenya is part of the commission. If we get to paragraph, I think it's paragraph 74. I hope I'm right. Paragraph 74 of their heads of argument.
Of whose heads of argument?
Of the evidence leaders' heads of argument. But I will get to that. They even say he gives advice to the commission. But I'll get to that. It is in my notes.
It starts at paragraph 73, the role of evidence leaders.
Yes, hence I think it's paragraph 74. But
it can't be paragraph 74. Paragraph 74 deals with the issues identified by Mr. DPA.
Commissioner, what I'm saying is in my notes, it's paragraph 74 of their heads of argument.
Yes.
Where they say one of his role is to provide legal advice to the party.
Yes, it is so.
I think it is paragraph 74.
It is 74.
Thank you, Commissioner. So what we say, Commissioner, is that he controls the evidential record. He decides and determines what goes into the record. He structures the questioning of the witnesses. In this way, he shapes the material that must form part of the record. His position as evidence leader is sufficiently linked or connected to the adjudicators. There is not a far distance between evidence leaders in general and the commissioners. Is
it not so that the evidence leaders don't make a recommendation with regard to the evidence that is presented before the commission?
Can I ask the chairperson to repeat?
Is it not so that the evidence leaders do not make a recommendation with regard to the evidence that has been presented before the commission?
that is the recommendation that will ultimately go to the president.
Yes.
But it's a process.
That is the role assigned to the commissioners.
It is a process. It is a process. It starts with him. It starts with him by presenting that evidence, by giving advice on that evidence. The commissioners will make a recommendation, but he is part and parcel of the machinery that lead to the producing of that record.
Advocate Wala, what is the role of the commissioners when it comes to the evidence? Do you see any role at all?
Of the commissioners?
Or are we just beholden to what the evidence leaders put before us?
No. I'm not arguing a case that says the commissioners have no role or have a passive role. The authorities in the arms deal case, for instance, it is set out. You are not going to be passive. The point we are making is, in you not being passive, there is a connection, a strong connection with you and advocates and the evidence leaders. I'm not suggesting that you are going to sit there and take everything that the evidence leaders are saying. That is not what
Yes. As I understand your submission, Mr. Gwala, is that the SARFU case is on point.
I'm going to submit, especially when I'm dealing with their submissions, that the test that rather should be applied is the SARFU test, not the test relating to the recusal of the prosecutors. And I'm saying it for these reasons that I've just said. The evidence leaders are sufficiently closer to the adjudicators than the prosecutors are.
But not the ultimate decision maker.
That decision,
that's the problem that we have.
That decision is shaped and informed by the material that is presented to you by the evidence leaders. When you get to that stage of making the decision, you will have had acted, even on their submission, that they will even give legal advice to you. If they were not that material, they would not have been appointed at all. The commission would just have seen how to deal with the matter. But I'm not saying it's redundant to appoint them. What I'm saying is, I'm demonstrating that they are an important part of the machinery that leads to the recommendations that will be made at the end.
Your time is up, Mr. Gwala. So if you would make your concluding submissions.
Can I quickly make the conclusions, Chairperson? I will be selective then because of the time, and I say the heads are already there. What they argue is that you should accept the test that applies to the prosecutors. For these reasons, we say no. The case about the recusal of the prosecutors are not of assistance in this case. Prosecutors, for instance, do not give advice to the accused person. They do not even represent the accused person. But we know that Advocate Meng is going to give advice to you. And we know that he gave advice to the NPA. Chairperson, they have in their heads of argument quoted paragraph 79 of SARF, where they say the president of there was an application for the recusal of the president of the court, and the court said the relationship between the state president and the president of the court had ended long time ago, and so on. We submit in that regard that the issue that was before the Constitutional Court was not an issue where the president of the Constitutional Court would have given advice on. But the issue that is before you is an issue that Advocate Menya has given advice on. So that is not of assistance.
But you're not suggesting that evidence leaders could manipulate the evidence or suppress some evidence. You're not suggesting that.
I don't want to go. We know their role. We know their role. But what we are saying is you've got a person now who has, on the very same policy, given advice on. He has got some information about that policy. He has been given, that is the case we're making, he has been given confidential information relating to that. We are not accusing Advocate Semenya of intending or appearing as if he's going to suppress some evidence. We are not there. We are on the facts, and the facts are simply that he has represented the NPA, and by virtue of that, he is conflicted. We are not accusing him of anything further than that. There is something that I must not leave, though, Commissioners. In paragraph 34, I will not go to all of this because of time. In paragraph 34, they say we do not set out, they say, I'm paraphrasing it as well, we do not set out precisely what role he played in the development of the policy. That is mischaracterization of the issue. The issue is not about the role he played in the development of the policy. The issue is that he represented NPA in defending the constitutionality and legality of the process. This is what is contended for in the founding affidavit of the NPA in paragraphs 18 to 29. And we remind the commissioners that pleadings define the issues, so the issues are as defined in those.
Yes.
Lastly,
Mr. Kuala, you are now on borrowed time, and it will be unfair to other parties.
I will leave it there, Commissioner, but can I just make this point? The argument about the lapse of time 17 years ago and so on is not the test. SARFU does not go to that extent. The test is SARFU.
Thank you.
Thank you, Commissioner.
Thank you, Mr. Kuala. Mr. Vani.
As the Commission pleases. Chairperson, we will try to be as brief as we can. We'd like to address the Commission on three matters. One, the role of the NPA in the recusal. Secondly, what we believe the test for the recusal of an evidence leader ought to be. And then lastly, we would like to address the Commission on the question of the evidence leader, Semenya SC. Starting with the role of the NPA, as the Chair and Commissioners can see from our affidavit and our submissions, we are somewhat troubled by the conduct of the NPA in this particular matter. In the NPA's affidavit, they admit that they knew from September the position of Advocate Semenya and the role that he had played in the Nkadiming matter, the challenge to the prosecution policy. To explain their inaction, Advocate Maga in his affidavit says that they were unaware of the extent and depth of the involvement of Advocate Semenya in that matter. That only came to light apparently recently. Our submission in that regard is that that's a contrived statement. As a matter of course, advocates representing parties involved in constitutional matters will be involved in providing advice. They will be involved in consultations. They will be involved in providing opinions and the like. And so far, we've heard nothing from the NPA to suggest that anything was out of the ordinary. We've heard the suggestion this morning that there are confidential matters that they are not able to put up. We doubt that there are such confidential matters. They might have been confidential back then, but we don't believe that there's any claim to confidentiality now. And if there are such matters, they should have been put up. And if they're truly confidential, then they could have been put up in an in-camera affidavit. And none of that has taken place. What's also concerning to us is that the allegation in relation to Advocate Semenya in regard to his involvement in the challenge is that he would be perceived to be biased against the families, given what the families argued in that case. We are told by Advocate Maga in his affidavit that the matters only crystallized, to use his phrase, when the issue about the Kalata group leading their own witnesses came to light. That was on the 27th of October. And we are concerned with the timing because it suggests that the NPA was happy to live with the conflict that they would have been aware of, or the alleged conflict, from September. They admitted knowledge of Mr. Semenya's position from September, but they were happy to live with that. However, when it emerged that the Kalata group had been given permission to lead their own witnesses, and that, of course, is an argument for a separate occasion, and I don't want to go into the ins and outs of exactly who gave permission, but it was only then that the issue of the prosecution policy challenge and Semenya's representation of the NPA and the minister then became an issue. And we suggest that this was an afterthought, and that but for the leading issue, the NPA would have been happy to live with that alleged conflict in relation to the prosecution policy challenge. Advocate Maga also denies that the NPA is responsible for precipitating the collapse of 3 weeks of hearings. And we point out that if the application for recusal was a serious one with real intent, then it should have been brought during September or October, or at least some time before the first day of the first hearing. The law is clear that when you become aware of circumstances that warrant an application, you've got to bring it at that time, and not simply on the very first day where the NPA sought directions. So from the perspective of the families, we believe that conduct in fact did precipitate. The fact that they did not bring their application in good time, that did precipitate the collapse of the hearings on the 10th of November. We now want to turn to what we phrase as the mischaracterization of the prosecution policy challenge. And we regard this as equally serious. Now, Advocate Maga denies that in his affidavits he mischaracterized the prosecution policy. The Commission will recall that there are several paragraphs which we refer to in Mr. Fenter's affidavit as well as in our submissions, where Advocate Maga appeared to be paraphrasing and at times quoting what was said in the challenge to the prosecution policy, the 2007 challenge. And there it was dressed up as a whole-scale attack on the grounds of political interference. In his replying affidavit, Advocate Maga says, no, we weren't referring to the 2007 challenge. We were referring to the founding affidavit of the Kalata application brought earlier in 2025, as well as the stay application brought by the President later this year. And yet, when we look at Advocate Maga's affidavit, nowhere does he even mention the Kalata application or the stay. So it's difficult to take that claim seriously. But even if we were to accept the claim that Advocate Maga was relying on the 2025 Kalata application, and for example, he says when he refers to the replying affidavit, he's actually referring to the answering affidavit in the stay, which was heard just a few months back. And yet if you go to the answering affidavit in the stay, the quote. And Chairperson, I'm not looking at paragraph 35 of our heads. That doesn't appear in the answer to the stay, and in fact the words prosecution policy don't even feature in that affidavit. But assuming that he was referring to perhaps the founding affidavit of the Kalata application, and in that application very serious allegations of political interference were put up, and the prosecution policy was but one measure that was pointed to by Mpanya Kalata in that founding affidavit. Those allegations were not made in the 2007 challenge. You won't find the words political interference in that challenge, because at that time the applicants were not in possession of any evidence suggesting that there was political interference. It was simply a constitutional challenge, as well as a challenge under the Promotion of Administrative Justice Act, PAJA. And our problem is that we regard that as a misrepresentation, because the NPA, or at least Advocate Maga, is attempting to paint a picture of a hopelessly conflicted Semenya, who at the time was disputing allegations of political interference, when in fact none were made in 2007. And that Chairperson, in our view, it probably was done inadvertently, but that is to mislead the Commission as to the state of mind of Mr. Semenya back in 2007 when he was representing the NPA and the Minister of Justice. We now turn to the test to apply. We've heard from my learned friends who are arguing that this Commission should adopt the test laid out in SAFU. We're all aware that that applied to judges, judicial officers, and decision makers. We've set out from page 10, from paragraph 46 in our heads, the test that we believe ought to be applied. We refer to State versus Zuma, and another, the citation is there, 2002. And we believe that the position of a prosecutor is closer to that of an evidence leader, or rather the position of an evidence leader is closer to that of a prosecutor than that of a judge. And we've quoted from State versus Zuma, the test in respect of the apprehension of bias of a prosecutor is not that which applies to a judicial officer. The tests are fundamentally different, and it is not axiomatic that a perception of bias held against a prosecutor will lead to an accused not having a fair trial.
Mr. Vani, what do you say to the submissions made by the applicants that with regard to a prosecutor, he doesn't give legal advice?
Well,
whereas in the position of the evidence leader, he gives legal advice to the commissioners.
Yes, an evidence leader will give legal advice to commissioners. A prosecutor, in the course of his or her duties, will make legal submissions to the court for the court's decision. We would suggest that the role of an evidence leader and a prosecutor, while different, are not so far apart as to be completely non-analogous. So, for example, if we look at the prosecution policy under the heading of the role of the prosecutor, and here I'm referring to the main prosecution policy, not the amendments, it says a member of the NPA must serve impartially and exercise, carry out or perform his or her powers and duties and functions in good faith and without fear, favour or prejudice, and subject only to the Constitution and law. They should not allow their judgment to be influenced by factors such as their personal views. And then under the heading trial process and related matters, prosecutors must present the facts of a case to a court fairly. They must disclose information favourable to the defence, even though it may be adverse to the prosecution case. And of course, that's a heightened duty when it comes to unrepresented accused. So we would suggest that there are similarities between the role of a prosecutor and the role of an evidence leader. They are required to act fairly and impartially, and we suggest that neither are decision makers, so that the test to be applied is rather that set out in the matter of Killian and Porritt. And with the lead of the court, we'd like to deal with what the test is. In Porritt and another versus NDPP, it's a 2015 SCA case. Citations are paragraph 51 of our heads. There the SCA talks about why the judiciary is held to a higher standard, because they are decision makers. Prosecutors don't make final decisions whether to acquit or convict. Their role excludes any notion of winning or losing. It is to be efficiently performed with an ingrained sense of dignity and seriousness. And Chairperson, the SCA there relies on the Canadian Supreme Court case of Buchner versus the Queen, 1955 SCR 16. So in that matter, Porritt suggested that the test in SAFU was not the test to be followed, but rather the test that laid out in Killian. That's Director of Public Prosecutions, Western Cape versus Killian, 2008 1 SACR 247. Also an SCA matter. And I'll just cut to the chase to say what the test Killian set out. The question remains whether the prosecutor's dual role in this case created a substantive unfairness per se. And we would suggest that the test in this matter for an evidence leader should be similarly framed. It should be whether the role of Semenya in the prosecution policy challenge would result in substantive unfairness in the ensuing commission of inquiry. And certainly in Porritt and in other matters, in fact, it did involve prosecutors who had been involved in litigation connected to the accused. And because there was no allegations of improper conduct in that matter, the SCA found that there would be no substantive unfairness. And again, no impropriety has been leveled against Mr. Semenya in that matter. It can't be claimed that he's been dishonest, that he's misled the Commission, or that he's acted vindictively. In passing, we note that both the NPA and the Minister allege that Semenya is biased because he's expressed, or he's claimed to be having favoritism for the families because he was involved in the deliberations in relation to the leading of the Kalata Group witnesses. And at the same time, he's biased against them because he was defending the prosecution policy challenge. And we suggest that there's an element of irrationality and logical inconsistency in that claim. How does one have a reasonable apprehension of bias even if one was using the higher threshold in those circumstances? So we would urge this Honourable Commission to apply the Killian test as set out. Then lastly, let us turn to the question of Mr. Semenya himself. We don't believe a case has been made out for his recusal on the basis of bias. We do not see him as being biased against or for any party in these proceedings. We believe he is more than capable of acting impartially and objectively. And it's not for that reason that we suggest that he ought to stand down. So we don't agree with Mr. Soni when he says that we are seeking his recusal. We're not seeking his recusal. We don't believe the case has been made out for his recusal, at least on the basis of bias. However, there are two reasons which give us pause. Firstly, The chairperson's ruling on the 19th of July stated that other evidence leaders would deal with all deliberations in relation to aspects and matters arising from the prosecution policy amendments. And in engaging in the interview with Dr. Silas Ramate, SC, who was at material times a senior official in the NPA, he was also an acting NDPP at relevant times. Mr. Semenya ought to have known that the prosecution policy amendments would crop up in that meeting, and he therefore placed himself in breach of the Commission's decision handed down on 19 July. Now, we don't say this was an intentional breach. It was inadvertent. But nonetheless, it does warrant him stepping down because it is a serious matter. Secondly, we turn to the question of whether he's able to...
Sorry, stepping down, what does that mean?
Well, preferably we would urge Mr. Semenya to act in the greater good and interests of the Commission by stepping down. But if he declines to do so, we are of the view that it is a decision that this Commission should take and require him to stand down.
Yes.
The other reason is equally important, perhaps even more important. If one looks at the role of an evidence leader, the role of an evidence leader is to put evidence before a commission that is relevant to its mandate. And such function ought to be efficiently performed. Now, given that the chairperson's ruling excludes Mr. Semenya from all deliberations in relation to the prosecution policy amendments, and this includes interviewing and leading or cross-examining witnesses who are likely to deal with those amendments, that excludes him from interacting with many key witnesses, particularly those from the NPA who dealt with the policy amendments over those years. And this really includes some of the most key witnesses that the Commission has to hear from. So at a practical level, it means he cannot participate in some of the most important deliberations of the Commission. And that's why, Chairperson and Commissioners, we are of the respectful view that the Commission should take the pragmatic decision of asking Mr. Semenya to stand down or requiring him to stand down in the greater good of the Commission.
Mr. Vani, you will recall that at the commencement of these proceedings, there was a point in limine that was raised by Mr. Soni.
Just remind me of that point, Chairperson.
With regard to the basis on which you are now making these submissions.
Yes. Let me deal with that.
Yes.
Chairperson, we are a party to this Commission. And we're entitled to be heard on these very important matters. We're told that these matters are not in the affidavit that we filed. In actual fact, in the affidavit of one of our attorneys, Mr. Fenter, he pointed out in no uncertain terms that there had been a breach and that we regarded the interviewing of Mr. Ramaita, knowing that he would deal with the prosecution policy as a breach of the Commission's decision. And so we are simply making submissions on those facts. And one of our submissions is that for the efficient running of this Commission, not because he is, in our view, biased, but for the efficient running of this Commission, that he be required to stand down.
And on what basis would the Commission have to find in your favor without any application having been made in regard to the issues you are now raising?
Chairperson, the Commission doesn't need a formal application. This is not a court of law. The Commission is entitled to make decisions that are in the best interests of the Commission and to determine its own procedure and ways of of reaching decisions. So the suggestion which we've heard from some of our learned friends that every decision the Commission has to make has to be on the basis of application, funding papers, answering papers, arguments, and oral submissions. We suggest that that is simply not as what anticipated in typical Commission proceedings.
Yes. Thank you, Mr. Vani. Your time is up. Thank you. Mr. Soni. I think you are inaudible.
Pull the mic closer.
Pull it closer to you, Mr. Mr. Soni.
Is this better, Judith? Is this
yes
better? Thank you. Jefferson, we've listened to with great interest to the issues that have been raised, both in the papers, in the heads of argument, and the oral submissions made today. We submit there are effectively 4 issues that the Commission should look at in making a decision on the application that Mr. Semenya be recused. And the first issue is, what is the test that would apply to an evidence leader as opposed to a decision maker? The second issue, and perhaps it is an issue that I should deal with first, is whether or what are the issues that arose in the Nkadimeng matter, and what are the implications of that for the Commission, and in particular, is there an overlap between the issues that arose in the Nkadimeng matter and the issues that are likely to arise before the Commission? The third issue is whether Mr. Semenya, whatever the position is, was in possession, firstly, of information which therefore disqualifies him, of information relating to some of the issues that might come up in this Commission, and does that disqualify him? And if it doesn't, was such information confidential? And the fourth issue, which perhaps I will just deal with very briefly, is does his agreement with Mr. Varney that Mr. Varney's clients could be led by Mr. Varney justify a basis for recusal? And of course, what I'd also need to deal with very briefly, Chairperson, is the submissions made by Mr. Varney as to the approach the Commission should take to Mr. Semenya's further participation in this Commission. Now, Chairperson, in the, and I'm going to deal with the Nkadimeng matter first. We deal with that at paragraphs 21 to 25 of our heads, Chairperson. You would have heard, Chairperson, both in the papers, in the heads of argument and the submissions of our learned friends, what happened in the Nkadimeng matter. Chairperson, what we do know, and what we know objectively, is what Lekodi J said in his judgment. That is what we submit should be the basis on which Commission should look at what the Nkadimeng issue were, what the issues were before that court, and effectively what the arguments were. The judgment is quite lengthy. It deals with those. I'll give just one example, Chairperson. It was submitted on behalf of the Minister that Mr. Semenya, one of the things he said in that commission was that the amendments were instituted bona fide. Now, if you look at the judgment, you don't find that word. There is the word male fide used in the judgment. Now, the point I'm trying to make, Chairperson, is once one quotes what was said in the judgment out of context, it creates a different impression, because the point I want to make, and I think it is a point made by all the commissioners, how does one decide precisely what were the issues before Mr. Semenya, before Judge Lekodi, for one, and what is it that Mr. Semenya said? Now, we know what Mr. Semenya said from the judgment because the judge records it, and nobody's challenged that. We also know what the judge thought the issues were, and the issues were very simple. Were the issues before him academic? Did the change in policy require or trigger a constitutional violation? And we know that the court found in regard to the second issue that that is the position, and he sets out his reasons for it. Now, what is it that goes beyond that the judge captured that would be of a confidential nature, which is what we are told would have been told to Mr. Semenya? But, Chairperson, this is not a matter that we addressed in the heads. I want to say that what one needs to understand about the Nkadimeng matter is how it arose. That only emerged when one looks at paragraph 70 of the minister's submissions, which she says what Mr. Bikoli said in an affidavit. I can't remember in which application it was, but Mr. Bikoli says in that affidavit, which is quoted at paragraph 70 of the minister's submissions, that this commission, the amendments were passed by Parliament on the 1st of December 2005. The reason that is important, Chairperson, is because the Nkadimeng case, and that one gets from the case number, was only instituted in 2007. Now, that is when Mr. Semenya's involvement with the NPA in regard to the Nkadimeng matter would have taken place. Now, at that time, all the justification for the policy would have been before Parliament, and Parliament would have decided what it is. What is it that Mr. Semenya would know about the policy, except, as Commissioner Gabriel has pointed out, that is public knowledge? All of that is public knowledge. And that is what Mr. Semenya would have argued. And we know, Chairperson, that when one looks at where there is a constitutional challenge, for example, to legislation, to policy, and so on, that is what one goes on. One goes on the text of the policy. The policy itself is not a mystery, because the policy is contained in Judge Lekodi's judgment. The whole policy is set out, A, B, and C of the policy. That policy tells you why it was necessary, on the basis of what was said in the policy, why the government found it necessary to change the NPA policy. So at the time that Mr. Semenya entered the scene, the policy was already at least 18 months old. So we have the situation that it is unlikely, in fact, it is impossible that Mr. Semenya would have been told what the purpose of the policy was. Because the purpose of the policy, Chairperson, we know this, comes from a reading of the text of the policy, unless there is further information. But Judge Lekodi doesn't mention any of that information. And that is what distinguishes what happened in Kedimeng matter with what is likely to happen in the Commission. The Kalata Group says now, and I'm not challenging what they say, and I say, we now realize, or we are now of the view, that that policy was introduced for a different purpose. And we think that that policy, those are the issues that we will bring to the Commission. So what is going to be brought before the Commission, which was not brought before the Nkadimeng matter court, is the people who formulated the policy and those who know why it was formulated. They are the ones who will come and give evidence. None of them appeared in the Nkadimeng matter. None of them deposed to affidavits in that matter. And I say that confidently because that does not appear in the judgment of Lekodi. Now, what is it?
Advocate Soni?
Sorry.
Would that also include evidence about the use to which the policy was put?
Between the period that it was in place.
No, I'm talking about the now sitting as a commission. Would that be the kinds of evidence that we would receive?
If that is the evidence that is available, that would be the nature of the evidence. But I want to also address an issue that comes out, Commissioner Gabriel, from your question, and that is in deciding what the purpose, whether the policy was constitutional or not. It would not have been necessary to look at the intention or the motive for the policy. All that one looks at in the modern parlance is what was the purpose of the policy, having regard to the text and the context within which it was introduced. And so I must make this point. The issue of the constitutionality of the policy is res judicata. Chairperson, and I say this, and commissioners, I say this with the greatest respect, it won't be appropriate for this commission to look into the constitutionality of the policy. The only issue that one would look at now are matters seemingly raised by the Kalata Group that they perhaps have information to say that the policy was introduced, no matter what it says, was introduced for a different purpose than appears on the policy itself.
And that is the decision that the Commission will ultimately have to reach.
Absolutely.
At the end of the presentation of evidence.
And Chairperson, may I put this in context? That is not the only issue that the Commission will look at. The NPA seems to say that is the central issue, but that's not what the terms of reference say. Terms of reference are much, much wider. Terms of reference says, is there any evidence that people interfered with or stopped police people from investigating TRC complaints or violations of human rights prior to 1994? And in addition, if there were such investigations, were prosecutors discouraged from doing so? So it's much, much wider. One doesn't even if one didn't have what the Kalata group is now saying, the Commission would still be dealing with those matters. And we know there is evidence to this effect. The prosecutor says we were told not to do this, we were told not to do that. So that is the nature of the evidence, and it is not central. The Nkadi Meng case is not central to the terms of reference of the Commission. The Commission has much, much wider references. In fact, I would be surprised if the Kalata complaint occupied more than a small section of the Commission's work that will unfold in the coming months, Chairperson. Then, Chairperson, let me get to the second issue that which I indicated was the first issue. What is the test in regard to an evidence leader? Chairperson, we've said so in our heads, and we say so again, that we know as a fact what the test in SAFU is, and I say as a fact because that is a principle of our law. It is the test set out in SAFU. Would an objective, reasonable person believe that the decision maker would not bring an independent mind to bear on the decision that he or she would be making?
Don't swallow your words, Mr. Soni.
I beg your pardon.
I say, don't swallow your words.
I'm so sorry, Commissioner. I say the SAFU test is essentially this, that with a reasonable person knowing all the facts, come to the conclusion, a reasonable conclusion, that the decision maker will not bring an independent mind to bear on the decision he or she is required to make. That's the SAFU test. Now, we know also that the Supreme Court of Appeal on 2 occasions has said that the SAFU test does not apply to public prosecutors. And it would be, in a sense, set in stone as well when it comes to questions of the removal or recusal of public prosecutors. We say that is relevant for this reason, that there are similarities between the role of public prosecutors and of evidence leaders. They both don't make decisions. They are in charge of leading evidence. We've set out quite extensively in our heads what the role of an evidence leader is. And we've also set out what the courts have said are the roles of prosecutors. And we believe there is a great deal of similarity. But we accept, and we make this point, we accept that that doesn't mean it needs to be applied, what the test needs to be applied in the same way as if we were dealing with a public prosecutor. We submit it won't be necessary for this commission to have a standard test that becomes the test for recusal. We say this on the basis of the decision in Branco, where the Supreme Court of Appeal, it's a matter we've addressed in our heads, where the Supreme Court of Appeal said that a tribunal or a court must be cautious about adopting a particular set of standards that would come back to haunt a different commission or whatever it is. And so what we say is that what the commission is required to do in deciding what the test in this matter is to look at the particular circumstances and say, is there a way that Mr. Semenia's continued participation in the work of the commission is going to be unfair to the public, to any participant, or to the commission itself? And that is the decision that would have to be made. And we say in making that decision, one of the things that must be taken into account is the test cannot be as high as in regard to in regard to judicial office or decision. But there is another reason why the test for prosecutors is an important yardstick. Prosecutors are not, on the basis of the judgments in Potterill and Killian, prosecutors are not disqualified from participating in a case where they have participated in earlier proceedings against the same accused. And both the Potterill and the Killian cases, we know that there were hearings in which prosecutors had interrogated the persons involved. Now, the Potterill judgment talks about the dual role of the prosecutors in that case and says that didn't disqualify them. The reason that is important is that both the minister and the NPA says the fact that Mr. Semenya represented them, the NPA and the minister, in the Nkadimeng matter is a justification for his being excluded now. But with respect, that cannot be true. It is because if the test of prosecutors is applied in regard to the dual role and prior knowledge. In fact, we submit that it may become unworkable for commissions to say that somebody who has had some knowledge of this matter may be excluded as an evidence leader, because it would just create chaos. One needs to adopt a common sense approach to this. The approach really is, what is it that would disqualify a person? We submit it can't be prior knowledge of the case, because there is no basis to say that an evidence leader with prior knowledge would act in an unfair manner. That's Mr. Semenya's position.
So the common sense approach must also be principled, mustn't it?
Yes, yes. On the basis of what yardsticks would one use to disqualify a person. Let us say that exactly the same issues that arose in the Nkadimeng matter are going to arise here. Maybe a basis to say, well, there should be concerns about the participation. And that's why I started off by saying there is very little in common except the fact that the Nkadimeng case dealt with the prosecution policy on one issue, namely its constitutionality, and this commission will deal with that issue in regard to, was there an ulterior motive to bring about that policy?
Yeah.
And we submit that at the end of the day, if the test, the SAFU test is applied, and some of the questions raised by the commissioners brings this out, and there is an interaction between evidence leaders and commissioners, which would happen in all commissions, what would the position of the commissioners be? Because they would also be privy to previous knowledge.
Can you pull the mic closer to you, please? Mr. Soni, can you pull the mic closer to you?
Sorry. Perhaps I should get closer to the mic. The point I'm trying to make is, can it be said that if the evidence leaders say something to the commissioners during a meeting to decide on which witnesses to call and so on, the commissioners are thereby excluded? And so we submit that if one adopts a common sense approach, one looks at to the extent to which that knowledge is going to impact on the decision that is likely to be made. Because position of commissions of inquiry, as was said by Justice Nugent in, and we quote this at paragraph 88 of our submissions, that while often called evidence leaders, that is a misnomer. The process of a commission of inquiry is inquisitorial, unlike that of a court. That means it must make its own inquiries, seek out evidence itself, and interrogate the veracity of evidence where that is required. Counsel appointed by the Commission facilitates the performance of all those functions under the direction of the Commission. We submit that that properly sets out the roles of the different role players and at the same time ensures that the decisions, that your decisions would in fact comply with the Southwest Standard.
Mr. Soni, we bring to our attention that your 30 minutes is about to expire.
As my lady, please. There are two issues then that I should raise. The first issue is, and it has been bandied around all the time, Mr. Semenya was subject to a conflict of interest. May I just say that in the Wishart judgment, which is referred to in the heads of argument of either the minister or the NPA, the matter at paragraph 34, the position of what it means to be involved in a conflict of interest is set out. It says, where the court's intervention is sought by a former client, the position is entirely different. The court's jurisdiction cannot be based on any conflict of interest, real or perceived, for there is none. That's a former client. The fiduciary relationship which subsists between a solicitor and client comes to an end with the termination of the retainer. Thereafter, the solicitor has no obligation to defend and advance the interests of his former client. The only duty to the former client which survives the termination of his client relationship is a continuing duty to preserve the confidentiality of information imparted during its subsistence. And so the test is not the possession of prior information, but is it confidential? And that is what I started with on account of this issue, that at the end of the day, is there any evidence that there was confidential information? When one looks at what those two memos from the acting
You are on
NDP.
injury time, Mr. Soni.
Can I just finish this?
Yes, we are interested to hear you with regard to the issue you raised as a preliminary issue.
Oh, on yes, okay. Chairperson, I accept Mr. Varney's submission that they have an interest in this matter. But at the same time, what they did was when the matter came up and they filed their papers, they adopted the stance that they abide the decision of the Commission. Now in their heads of argument, they say, no, but we say that if Mr. Semenya doesn't recuse himself, then he should be recused by the Commission. We submit, well, firstly we submit there can be no basis for that. But we submit it's unfair that Mr. Semenya has not been given an opportunity to deal with this issue in an affidavit, and the Commission doesn't know what Mr. Semenya's stance on that is, and hasn't heard his answer, and it would be unfair to make a ruling on that issue.
Thank you, Mr. Soni. Ms. Moroka, any reply?
Very shortly, Chair. Commissioner Gabriel has asked a question twice, I think, about
You are not
about the role of. You see, when I sit down, I can't talk.
Yes.
About the role of the commissioners. And then I did refer her to the case of the Armsdale case. That sets out what the inquirers or the commissioner's role would be: to inquire, to test, to prod and poke. And I agree fully with Mr. Soni in the case that he's just quoted about the Nugent judgment, where it also sets out what that role is. And it underscores and emphasizes what we also say about the role of evidence leaders, that they, in a sense, are the conduit through which you do your work. They lead the evidence, they test, they interview, and therefore to say that they are like prosecutors, we would again beg to differ, because the role of a prosecutor is completely different. There is no way that a prosecutor and a judge can have such a symbiotic relationship. It would be highly unlawful and untenable. That's the only point that we wish to make in that regard. Mr. Soni also talks about the fact that if you have some knowledge or prior knowledge, that in a sense does not impact your ability to be fair. And I would want us to return to their heads, the evidence, not the evidence, yes, it is the evidence leaders. Paragraph 44.3 of their heads, which is on page 91, where the evidence leaders say to this commission that unlike decision makers, which evidence leaders are not, and we agree they're not decision makers, there is no obligation on evidence leaders to bring an impartial mind to bear on the proceedings. We are horrified by such a submission, that an evidence leader will be partial to one or other parties, and the only proviso is that they are fair. Fairness and impartiality, we would submit, go hand in hand. And it's a very odd submission from the evidence leaders who are supposed to work under the direction of the commission to say we don't need to be impartial. We can be as partial as we please. I think that statement tells you why we are worried about the impartiality of one evidence leader. And again, we wish to emphasize that we have not said that Mr. Semenya has done anything wrong, except with a connection with the discussion with Mr. Vani. Other than that, we make no submissions about his conduct. The only submission is that it's an apprehension of bias that we are concerned with. The questioning of Mr. Gwala by Commissioner Homo and can't remember who else, talked about prejudice. Our submission is that the test is not about prejudice. The test is about apprehension of bias. If there's an apprehension of bias but from previous conduct...
Apprehension of bias or reasonable apprehension?
Reasonable apprehension. Thank you. I'm indebted to you. I nearly said your lordship. But I am saying it is an apprehension and it's a reasonable apprehension, and the standard is an objective one. that a reasonable person would hold that this person, by the conduct or his former conduct, there would be an apprehension of bias. So, and the inquiry is, all I was saying is that the inquiry is not about prejudice. To the question that was asked about to Mr. Gwala. But having said that, if I may again talk through conflict of interest, that Mr. Semenya is a practitioner who is obligated by the code of his code of conduct by the legal practice council, that he has himself not to make himself open to any conflict. That where there is an apprehension, he must then ask himself that question. And as Mr. Vani would say, step down. We're not sure what step down means, but it's a question where he asks himself, should I step down because of a reasonable apprehension that might be held by any party to the Commission? Lastly, if I may, the question that arises about the policy and the fact that this is historic. The letter that was written by the 18th of September letter, if I may just rush to that, talks about the concern that the applicants have. It says, that letter says, at paginated 62 of which bundle? Of bundle D. Is this bundle? Oh, my apologies, it is bundle A, and it is page 62. At para 5 and 6, our clients intend to put up the amendments to the prosecution policy as a key example of how the South African government sought to intervene and block the bulk of the TRC cases from proceeding. They tell you today that they do not agree with the applicants, as it were. This is Mr. Vani. They do not agree. But at paragraph 6, they themselves say, in order to avoid any public perception of partiality or conflict, we would respectfully submit Mr. Semenya should not be involved. I was asked at a point in time, not today, whether I'm blowing hot or cold. I would submit this is blowing hot and cold. Because in one sense, they are saying that in order to avoid public perception or perception of partiality or conflict, which is what we are claiming, they today say they don't agree with us when we say to avoid this, Mr. Semenya must recuse himself. So, in conclusion, really, it is not about whether Mr. Semenya had confidential information that he shared with the Minister of Justice. It is about the fact that in terms of the very definition of conflict of interest, Mr. Semenya represented the minister in two separate, represented the ministers of justice who were then in office in two separate occasions, and therefore we are of the view that he is conflicted, or there is an apprehension of conflict, and he must be recused.
Thank you, Ms. Moroka. Mr. Gwala.
Thank you, Chairperson and members of the Commission. Just one point to make. May I take you to page 94 of, may I take you to the heads of arguments of the evidence leaders? They summarize what I want to say. And I take paragraph 49, it's page 94 of the panel. Paragraph 49, it is a reference to Sarfu case. If the commissioners are on that page, the quotation is paragraph 79 of that judgment. Just below the bolded part, where they say there have been countless cases in our history where judges have adjudicated dispute in which party has been a client prior to their appointment, by his appointment as a judge. Then the court says, of course, where judges in their former capacity as advocates either advised or acquired personal knowledge relevant to the case before the court, it would not be proper for them to sit in such a matter. We say Advocates Menu has advised the NPA. At least that one is there. On the lower test, the common sense test, as Justice Homer puts it, if we do not apply, well, I would accept that, but if we do not apply the SARF test, then it means the test is much lower. Anybody can come and say, because Advocates Menu represented and advised NPA and Department of Justice, therefore he should have been recused. But we still say the test to apply, it is better that the SARF test or yardstick sets a better standard than opening it for everyone. But if that is the case, it's even worse. Lastly, the counsel for the Alata families was dealing with what he calls a misquotation, which ultimately leads to misleading of the papers. The commissioners will remember that argument. I don't need to deal with that. I just want to give the commissioners their references in the replying affidavit where that aspect is dealt with. It is.
We have read the replying affidavit.
Thank you, Commissioner. That will be all.
Thank you, Mr. Kwala.
Yes, I
can close the proceedings. These proceedings stand adjourned for the day. The ruling is reserved.
Housekeeping announcement.
Yes. Ms. Muroka and Mr. Kwala. Mr. Kwala is missing.
But his junior is here.
His junior is here. It's not.
Oh, okay, sorry.
Chair, I'm for the SAPS.
Okay. Do we know where Mr. Kwala is? Okay. Sorry about that. I forgot some housekeeping announcement to make. I want to make inquiries from council whether they will be available to argue the objection tomorrow. May I just make inquiries, Ms. Moroka? Yes.
Chair, for the SAPS, I will have to check with my leader, but I'm already committed in court tomorrow, Chair.
Pardon?
I will have to check with my leader, Mukwena.
Oh,
see.
okay.
For me, I'm not available. and
You are
he's
not
going to be the one
available.
to argue it.
Yes. Mr. Vani?
We are available, Chair.
Ms. Moroka?
If I could have a word with my junior here, because at a point in time I was representing both the police and justice, so it might just be that I will, if her leader is not available, I'll carry the can. Thank you.
Yes.
I will be available, Commissioner.
Mr. Vani? Mr. Sodi or Mr.
Commissioner,
Nalani?
yes, I will be available.
Yes. Okay. You are waiting for? Okay. Should we take a short adjournment then? Of how many minutes? We'll take a 10-minute adjournment. Yes, ma'am.
Thank you, Commissioner. I've spoken with my leader, Advocate Maneche, and Ms. Malvangwa, special motions court tomorrow. It might spill over to Friday, but one of them can avail themselves for Friday, if that is a date.
For
that
Friday?
can be considered, yes.
Friday?
Yes.
Okay. Yes.
Chairperson. This one's Chair. From the SAPS side, tomorrow, again, is a challenge similar to...
You have a similar challenge?
Same, we are in the same matter tomorrow, but
Okay.
Friday, we're also flexible because I can avail myself.
So you can be available on
If
Friday?
it has to be on Friday.
So shall we agree then that the objection will be argued on Friday at 10 o'clock?
Thank you, Chair.
Ms. Moroka?
The old lady is available, Chair.
You are available? Okay. Mr. Vani?
We're also available, Chair.
Okay. Mr. Kuala?
I will make myself available, Chair.
You are available. Mr. Nalane?
Make ourselves available.
Okay. Okay, fine. Thank you very much for your patience. We are adjourned.